So who am I? Len Harris. I live at Mareeba, North Queensland. I live on my mining leases, so technically I do not hold a parcel of land in Queensland, and other than a very, very big hole in my pensioner savings, I gain nothing through what I'm doing. So it sort of cuts the guys off that say, oh, I haven't had a lady say this, and I say, oh, yeah, but what did you get out of it, right? Nothing, zipper. I do it because what the government has done is wrong, and it has hurt every one of you. So I'm in this for the long haul. This is not going to end on the 18th of February, irrespective of whether the judge favours Queensland government or us. So who's the silent majority? Well, I thought there would have been an odd hand up here. We, every one of you, hands up. We are the silent majority. And the lovely thing is, there's more of us than there are of them. So, how did this story start? It started in about April, late April last year, when a friend who knew of my period that I was in the Senate asked me to help a young family who were being evicted from their parents' property. Long story short, I helped Leon lodge an originating application to have the writ that the court had issued for the mortgagor to take possession of the property, and it hasn't been settled yet, but they are still in their parents' home. So that's what actually started me on this long chase. So the first thing I did was I went to the 1994 Lands Act and also the Lands Title Act. I was looking for a section that would tell me what rights that the mortgagor had and what rights the mortgagee, being Leon and his father and siblings, had. I couldn't find it, and that took quite some time working it out. So eventually, a lot of people here would know the term something falling off the back of a truck. Well, there is a modern day version of that, and that's when I receive an email that doesn't have a name on it, and it doesn't have an IP address either. How the hell it gets to me, I don't know, and I don't want to know. Anyhow, the act of the email said, Len, we think you should look at this act, and that is the act. Now, I'm not going to talk about it straight up, because the only reason the Queensland government could actually bring this act either through the Parliament or possibly by reprinting it. To work that out, we need to go right back to where the rot started in Queensland. So that's back to 1987. And the Premier then was Mike Ahern. And it really, really saddens me that we have a National Party government, and they actually won that election outright. There was no Liberal joint Conservative. It was the Nationals by themselves. And I believe this is the answer as to why the party had to or some members of the party had to get rid of Joe, because no way in the world would they have ever got this act past Joe. So what is the act? The act is the Constitution Officer of Government, Constitution Office of Governor Act 1987. When I pass these around, there's a particular thing I want you to have a look. I want you to have a look at what was the original act in 87, and this is an act, the same act, but it had been amended. And what I want you to look at are the two crests. On the first one, we have Her Majesty's crest, which is the lion and the unicorn. In the later ones, it actually has a deer and a brolga. So that is not Her Majesty's crest. And the best way to explain the significance of that is growing up in a little town called Toogoolawah up the Brisbane Valley. Like all young guys, we would get a little bit toey, maybe driving past cars. Unfortunate for me, my parents lived opposite the police force, the police station. So it wasn't very far for Sergeant Neil to walk over in his blucher boots, his short, and his Jackie Howe singlet. So if he was dressed like that and walked in, he was over for a cup of tea. If he had his hat on, we were in deep doo-doos. So, and the difference is that on Sergeant Neil's hat was Her Majesty's crest. So he could be in anything. He could be in his swimming tights. I never saw him in them. It wouldn't be a good sight. However, the moment he put his hat on, he was under the crown. And he had every right that an officer has when they are under the crown. Have a look across the road. Yep, it's there. The little checker sign there, that they must have stole that from David Jones. So that's what's around the band on their hat. Are they under the crown? No, they're not. So technically speaking, your average police officer has no more power than a chick at Woolworths or Coles. They are both corporate entities. But I'm not suggesting that you take any actions related on that. But be aware, if you are stopped by a police officer, always be courteous. Ask him or her to see their warrant card that has been personally signed by the Commissioner of Police and sealed with the seal of Queensland. And you normally get, here's your licence, have a lovely day. So, the difference is the crest. To be an officer of the Crown, you have to be under the Crown. They are not. So what did Mr. Micahane do? Well, back in 1922, the Labor Party cancelled the upper house in Queensland, the Executive Council. And we need to go right back to that because this Act impacts on that. So in 1917, the Queensland government held a referendum of the population, and the referendum was to either affirm keeping the upper house or removing it. And there are a lot of bogus stories out there that those people voted to get rid of the upper house. Incorrect. When the referendum was held, 1,600 and some odd people, I don't mean they or odd, but numerically, voted to keep the upper house. Only 1,200 people voted to actually get rid of it. So the referendum, it didn't fail. The referendum kept the upper house. Back then, the governor themselves, as part of their duties, appointed the members of the upper house. So the governor of the day appointed another 14 senators, and before they were sworn in, they had to sign a pledge that the only reason they were being appointed as senators was to vote the upper house, the executive council, out of existence. So God has a real wicked sense of humour, like he did today, having me run around here like a chook with its head cut off. So they put the question, and to everyone's amazement, it was voted down, so that the question was to disperse with the House, and no, it stayed there. So the governor then added another 4 senators to it, to the upper house. So now he's stacked the upper house with 18 new members, and their only intent was to vote it out of existence. So the next time that vote was put in 22, yes, the House voted to remove itself. That in itself raises questions. Where does the House get the power to dissolve itself when it was actually appointed by proclamation by Queen Victoria? And just while we're on that for the moment, when Queen Victoria she didn't, but when the Parliament in New South Wales, right, there was the colonies actually had parliaments by the mid-1800s, 1857. So New South Wales brought a bill into the House and passed it to actually divide New South Wales in two. That actual act was then physically taken to England, so you remember there'd be at least 6 months in that, getting back over there. It went through the House of Commons. The House of Commons weren't happy with it because New South Wales had asked if the division was to go ahead, that then both states would have the right of appeal to the Privy Council. And that still stands today. They'll tell you whatever they want to tell you, but in actuality, Rod Colleton, with his members of his legal people, have been to the Privy Council in relation to certain matters, and I'll talk about that a little later. So, eventually they resolved that issue in the House of Commons. The Act then went to the House of Lords and was passed. So then when Queen Victoria made her proclamation, now I'll just explain, a proclamation is very, very different to letters patent. Letters patent is like a contract between the Crown and whoever is receiving the actual document. So it's normally a personal document that we don't know the content of. However, because this particular proclamation was so important that we actually have copies of it, copies of the whole proclamation. So Queen Victoria stated that with the Parliament in Botany Bay, the House of Commons, the House of Lords, and in and through the Lords Spiritual and the Lords Temporal, I proclaim. So it just wasn't Queen Victoria making a statement, that was backed up by both parliaments in England and then the New South Wales Parliament as well. So that cannot be changed. Letters patent change from time to time. So in Queen Victoria's proclamation, she gave Sir Ferguson Bowen full force and power to dispense land of the Crown. And she gave him some very distinct directions. So Sir Ferguson Bowen, not the Executive Council or the Legislative Council, right? Sir Ferguson Bowen was told to actually create folios, appoint members authorised to make entry into those folios. The land of the Crown that was to be dispersed with must have been surveyed. It must have been awarded a lot number. So the lot number that you have today on your property, you hold by virtue of Queen Victoria's proclamation. You hold your title because Queen Victoria said that that land had to be put to public auction, and when it was purchased, then Sir Ferguson Bowen was to instruct the officers to register that in the folios, and then the last order that he was given was every document had to be sealed with the Great Seal of Queensland, which she provided. So that's why on the really old parchments, you can actually see the Great Seal of Queensland. It was embossed, but this deed was issued on the 7th of July 1923. So next year, that deed will be 100 years old. And according to the Queensland Government, it's not worth tiddlywinks. It is a historical document to look at. And there are hundreds of those, particularly out in the rural areas where you have 5 and 6 generations who are still living on the same property. So we hold our title deeds by virtue of the instructions from Queen Victoria in that proclamation. So where does the Queensland Government get the power to alter it? So it's a certificate of title. One of the most important things that you will see, if you look down on the third line, it says seized of an estate in fee simple. In the Westminster system, there is no legal title called freehold. It is purely something that governments have just snuck in under the carpet because they cannot pass laws over fee simple. You hold your property in fee simple as a contract between you and the Crown. And as the High Court has said back in 1927, in Commonwealth versus New South Wales, Sir Isaac gives a very amazing description of your rights. Now I will, it's one of the thousands of things I've got to do. Yes, Len, get it up on the bloody web. I will. Okay, so you seize your property. The next thing to look for in this dark section, unfortunately the deed at some stage fell into two parts and it was sticky taped together and then eventually put in the plastic. Right down in the dark area on the left side, you'll see a number and it's N7466. That's the number that is allocated to the deed of grant for this title deed. So in actuality, your titles for your property are in two parts. One is the actual title itself, and the other is the second document that actually tells you the reservations to the Crown. And it is important to know what those reservations are. So if you want to find that out, I suggest to people you go to the Department of Natural Resources, or DNR. You get your property number, the lot number of your council rates, and you ask for a copy of the electronic lodgement for your lot and the associated deed of grant. Now, I'm not saying this would refer to anyone here, but I actually had a gentleman, I have been doing this sort of thing for over 30 years. And I was on the Darling Downs near Taroom, where the power station is, and this gentleman bought a copy of his title and his deed of grant. And when I looked at it, so his property adjoined the property where they built the powerhouse, and the Crown had not reserved coal. So in actuality, he owned the coal under his property. Just like that, he was a virtual millionaire, because the Crown could still allocate the right to mine the coal, but he got all the royalties, not the state. So the other important reason for getting a copy of your title, now that they are digital, is to make sure if you own it outright, yours is the only name on it. And we're doing a test at the moment because mortgages are no longer attached to the title like they are here on this deed. The other two things to look at when it's going around is that there is the surveyor's survey of the lot. So you know exactly what the nets and bounds are on your property. Like, you won't get it today, but that's what we're working on. And the other thing is, over this side, you'll actually see the very faded but very old Great Queensland seal. Mrs. DiMaggio's husband died just prior to 1990. She wanted the title correctly moved singularly into her name, and she had a diggins of a fight because they wanted to take, and this is 1990, they wanted to take this title and not give it back. In other words, they were going to shred it. So she persisted. The only reason they would concede to letting her have the title back is on the back of it here, owner's copy of title cancelled. So they knew this was in the wind back in 1990. Okay, so your job, as soon as you got that out of the van, when I leave here, it's on you to make sure it's back in it. Oh yeah, of course. I've lost it twice. And praise the Lord, got it back. So that's okay. Now the reason why I went right through all of that is because in this act, in 1987, Micah Hearn, the first thing he purports to do is to re-establish the Executive Council in Queensland. Now, where does the Premier of a state get the head of power to recreate something that the Labor Party had voted out of existence? Well, that's a question that Justice Henry is going to have to consider on the 18th. He then makes the governor not the governor of Queensland, but the governor as governor in council. So the effect is he's made the governor, instead of being Her Majesty's representative, and part of that was to reserve bills if the government was oppressive, like this one. The governor should reserve that for Her Majesty's pleasure because it offends you and I. That's the role of the governor. He or she is supposed to be that watchdog there to keep, the pressure on the government. So, and that when you actually go to the back of the Act, you'll find it where he's actually repealed the section that allows did allow the governor to reserve bills. But the worst thing that he did, and this just absolutely astounds me, in section 13, isn't that irony? For as long as the provisions of this part are in force, the provisions of the letters patent constituting the office of the Governor of Queensland made by Her Majesty Queen Elizabeth II on 14 February 1986 and proclaimed in the state by the Governor. I refuse to put the word excellency in front of them. They are not. So on the 14th of February 86, proclaimed in the state by the Governor on the 6th of March 1986, are suspended in their operation. So the effect of that is that since 1987, we have never had a parliament that has been actually proclaimed in the name of Her Majesty. That is where the rot started in Queensland. That is what has allowed all subsequent governments from 1987, and they have to have a majority to be proclaimed the government. As soon as they pass a bill through the Legislative Council, it's law. All that has to be done then is sent to the government printers to be printed, because when it comes back to the governor is, what's the governor now? I told you before, see? There's trick questions at the end of this. Governor in council, right? Again, governor in council. So he is no longer there to represent you and I. So we'll keep these two together so you can actually see the difference between the two seals. It was Micah Hearn that Labor did way back in 22, but in modern history, it's Micah Hearn who started the rot. So because Micah Hearn did what he did, right, when the infamous Peter Beattie brought this act in 92, so Micah Hearn is 87, right? Peter Beattie is 92. he brought in an act called the Reprints Act. Now, the purpose of the act basically is if there is diction that is incorrect, or a spelling mistake, or a comma, or a full stop somewhere where it shouldn't be, right, through the act, the bureaucrats, you ever misspelt bureaucrat when you're typing something? I have heaps of times. How did it come out? Can you remember? Well, mine always comes out as Bearcats. Anyhow, so that's the intent of the act. It is just to fix up minor changes in any legislation, or if the government brings a bill into Parliament, passes it all the way through, and it is supported. Well, it's going to have to be, because the government is the government, right? Then the Bearcats in the back office can actually then either add another section in or take a section out, okay? Then the act is sent off to the government printer, comes back from there to where? The Executive Council, right? Who reinstated the Executive Council? Micah Hearn. So the reason that this act is where it is today started with the changes that Micah Hearn made. So when you go to section 8, okay, editorial changes not to change effect. Section 7, and that's all of the changes that it can make, does not permit changes to the text of a provision of a law that would change the effect of the provision. So that's clearly saying you cannot change an act with this act. Can't get any better. So here's your test to see if you're listening this morning. Okay? Questions on this one at the end? And this is called, it's section 22, remade law of provision. So this is a subsection 4 under section 22. If a law provides that reference to a law or provision of a law, and then it has brackets, the first law, okay, so we've got one law, is a reference to another law or provision of the first law or another law, the second law. The first law is taken to have been replaced by the second law in all appropriate contexts. It's just to show you the idiocy, and I've had several people try to nut it. I have sat down with pencil and paper, and Micah Hearn in 87, Peter Beattie in 92, in that this is a Queensland document, and I say document because it doesn't say it's an act. Yes. So where did it come from? In actuality, New South Wales in 2012, yes, Mrs. Someone pronounce it, Berejiklian? I just say wheelbarrow, it's a lot easier. Berejiklian. Thank you. I prefer wheelbarrow. Okay. What she did, she brought an Act of Parliament through the New South Wales Parliament, and it went past through both houses there. And the Act was Electronic Lodging Act of New South Wales 2012. Now, it wasn't so much what the Act was, it's actually what she did with it. Well, no, actually, my apologies, she wasn't the Premier then. Anyhow, the Premier of New South Wales then took that Act to COAG. Now, how many people know anything about COAG? Anyone over here heard of COAG? Lots of shaking of heads. Hands up here. Anyone who knows?
That's now the National Cabinet.
Wow. Okay. No. Well, in a way, this is good because you're really learning about the system this morning, and that's the whole purpose. It's taken me 7 months after having 6 years in Canberra to understand up until now, and I'm not saying I know it all. This thing is just like the rabbit hole. The further you dig, the deeper it gets. So, the Premier of New South Wales took that act, the New South Wales Act, to COAG. And when 75% of the actual states agreed to accept it, right, it became binding on the other 25%. So in actuality, there was 5 Labor governments and territory governments, and there was only 3 Conservative governments at that time. The unfortunate thing was that New South Wales was a Conservative government, and it was their bill, so of course they supported it. So once they had 6 supporting it, the other 2 have no say, because they have all signed what is called an IGA, an Intergovernmental Agreement, and that's the rules. So what happened then was that COAG itself then put, sitting over the top of every registrar, so they're the people who register your titles, they put an entity called ARNEC, and it's first cab off the rank in this document when I get past the index. So ARNEC means the Australian Registrar's National Electronic Conveyancing Council. So again, COAG has no legislative support. It has no constitutional standing. So this entity just sits out there, but overarching the whole of Australia. Now, COAG no longer exists now. It is now the National Cabinet. And I think everybody would have heard of that. Yeah. Okay. So staying with COAG, COAG then created ARNEC, the Australian Register's National Electronic Conveyancing Council, established by the Intergovernment Agreement. So this is an act that Queensland has what they call mirrored the New South Wales legislation. So your properties and your title deed is now controlled by an Act of New South Wales that the Queensland Parliament has never ever had any debate over, and Queensland by themselves cannot change it because it's locked in by the Intergovernment Agreement. So just let that sink in for a minute. We've got a New South Wales Government Act that controls your title. Yes, that is a wow. And it's actually known as the Electronic Conveyancing National Law Queensland. And it does not have the word Act after it. And yet your titles are bound by it. So then we jump to the monster. This is a Queensland, well, I will say it is a Queensland Act. I'm unsure whether this is a reprinted act or whether it did go through Parliament. I suspect it did because the lovely young grazier, John O, was at the Rockhampton meeting. Hell, that was yesterday. And he is pestering his local member for a copy of Hansard that showed how he voted on this act. And he's pushed them that hard that the staffers now of whoever that MP was, this estate, wrote back to him and said they have been instructed not to engage in any more correspondence with him at all. So if you really want to ping, but you put your own word in there, your local member of, take a photograph of this, although actually it's in your document. We're now on the back page, so, and it has, Mrs. Palachuk, and that's how her name is pronounced in her country, Palachuk. So the name of this is there, so write your local member a letter and ask he or she to actually provide you with a copy of the Hansard when this act was passed in the Parliament, because if they're LNP or any of the other smaller parties there, or there are a couple of independents, there should be at least one out of 93 members. Surely somebody had to object to this, because if they didn't, they certainly weren't doing their job, any of them. Okay, so how did they cancel all of our titles? First of all, at the start, it states on 1 October 2019, this section of this act. Now this act actually alters 13 other primary acts, and that was part of the problem I had in finding it. I was looking in Hansard for a bill that amended the Land Act and the Land Titles Act, and there's none, because the bill was to amend Land, Explosives and Other Legislative Amendment Acts 2019, and that becomes significant right towards the end as well. So 1 October was when the section that has actually implemented or impacted on our titles is there. And just for everybody, to make it easy, it's page 266, because this will, as it gets passed around. So the second thing they did was to actually, in section 241, omission of Part 3, Division 3, certificates of title, and then it says underneath it, omit. So the way the power of our government functions, for the government to be able to carry out an action, there must be a succinct power that is in an act to do it. They just can't wake up one morning and say that they're going to ban all sailing boats, right? There has to be an act come through Parliament that is voted on, and if it says yes, we can get rid of all sailing boats, well, the job's done. But they can't just wake up one morning and say, oh, we've changed our policy, we're going to get rid of all sailing boats, because that would be just like that challenge. So by removing the word omit in 1 October 2019, the government from that point on cannot issue a title. So anyone here who has bought a property since 2019, there's usually one or two. Yeah, there's one lady there, another gentleman there. Did you get anything? No, nothing, because the government has removed their ability to issue a title. Over the page, and this is the one that cost me many long late nights, Section 242, omission of Section 75, they removed equitable mortgages out of the Act. Same situation. So now the Queensland Government does not record mortgages that are established in Queensland. And yeah, you can close your mouth. No, this is funny. That's what I've coined the wet mullet look. You know, you slap somebody with a week old mullet, and then the look is, and that happened in the courthouse. Not even the Deputy Register of the Supreme Court of North Queensland knew anything about this act. And that was his face, because while his lady was out the back writing out all the forms for me to fill in to start this, I showed him this, and that was, he was looking at it and he just could not believe. So subsequently, and I've been in there about 7 times, and look, this, I can take one look at it, read it, understand it, but then as far as procedure goes in the registry, not real good. I might get a B, certainly wouldn't be getting an A, but the lovely ladies there, I've been in 7 times, and I'll go back again twice, because I have to amend my original argument to include all of these acts. I will also, when I get home, there are hundreds and hundreds of affidavits that are all going to be filed when I get there. Good. I'm getting the thumbs up. So, but these ladies, they'll say, oh, Mr. Harris, that paper that you've got setting out all of the parts, that shouldn't be in front of the affidavits. They don't need it. It needs to go over here. And they go, click, click, pull it off, put it here. So they have just been fabulous. So, back to the job. So, Queensland no longer registers mortgages. I have a young couple in Ipswich who are currently at the moment asking some very well structured questions now we will get to it in the next act, the Queensland Titles Registry Proprietary Limited. Oh, yes, it's one of them. So they are inquiring of that private company, where is my mortgage stored? Where is it recorded? Because it certainly isn't in the little bit of binary code on one of the 3 computers, private computers, that your title is held currently as we sit here. The Queensland Government does not record anything to do with land other than maybe leases and things like that. But your personal property title is not held by the Queensland Government. It is either on one of 3 private companies. So remember we were talking about ARNEC, the overarching over the tops of the registrars. They actually authorise these private companies to hold your titles. The major one is PEXA, and it actually holds 70% of all the title deeds in Australia. So now we know that from 1 October, anyone who's purchased a property does not get a title at all. If they own it outright, all they have is the conveyancing documents, and they are not proof of ownership. It's only that legal piece of binary code that is the legal title. So what did they do with everyone else who purchased before them? In section 215, it states, certificates of title cease to be instruments. Well, why didn't they just say certificates of title cease to be valid? No, they've got to turn them into instruments. On the commencement, a certificate of title ceases to be an instrument under this Act. B, ceases to be evidence, conclusive or otherwise, of the indefeasible title for the lot for which it was issued. So that means since 1857, starting with Sir Ferguson Bowen, every title that's been issued by what was the title's office no longer is valid. And the only media thing, and it wasn't a government one, it was a legal opinion back in 2019 that says they are now historical documents to look at. Yeah, that was announced from that gentleman. Now, so we've got to have a little bit of humour in this. Humour in legislation? Well, I think it is, because, so I've read you section 1. This is the start of the words in section 2. To remove any doubt. Would you believe when you're reading something the government has done? No? Oh, come on. I'm from the government. Okay, to remove any doubt, it's declared that subsection 1 does not affect A, the indefeasible title for the lot for which the certificate of title was issued, or any interest in the lot for which the certificate of title was issued. So in one hand, they're saying, well, thank you very kindly, your certificate of title are now worthless, but by the way, we're guaranteeing you still own your property. Who believes them? Hands up. That was a trick question. Nearly caught you. Yeah, so the government is saying emphatically, even though the title deeds that we actually issued you are now no longer void, but we're guaranteeing that you still own your property. So, that's the Act, okay? If you wanted to hide the worst part of anything that you've done, where would you put it? Right on. And this ranks up there with them actually cancelling your title deeds. This is as worrying. So it's the Land Act 94, section 29(1), and it's a note. And it has omit and a comma, and then insert. And this is what, so they're taking out whatever the note was in the Act before, and they're inserting this. Chapter 6A, Part 3, deals with the power of an authorised officer to enter a place, including a place that is freehold land or non-freehold land. So where are we now? We're in a park, aren't we? Is this a place? Yeah, of course it is. Go across the road to the police station. Is that a place? Yeah, of course it is. Is your home a place? Yeah, it's my place. Right? So what this is saying, and I'll read it again really slow, Chapter 6A, Part 3 deals with the power of an authorised officer to enter a place, including a place that is freehold or non-freehold land. When you look at the Act, and it actually alters 13 other acts as well, any other authorised officer under any of those acts, they are saying has the right to enter your home. Well, we've got news for them. There's 4 High Court rulings that are what they call unanimous. Now, back in 1923, there was only 5 judges, so don't be put off if you ever go and have a look at Commonwealth versus New South Wales. There's only 5 judges. That's all there is. So all 5 judges in a case called Commonwealth versus New South Wales. New South Wales had transferred land to the Commonwealth to make, say, hospitals, ports, railways, post offices, all of those sorts of things. And in some of them, or even only one, it doesn't doesn't clearly, succinctly say, there were minerals found that were quite valuable. So New South Wales tried to actually infer, yes, we've transferred you the ownership of the land, but we haven't transferred you the minerals and everything that are reserved to the Crown. So the Justice Isaacs, and I have trouble when I have to write that. I think it's ISSAC, Isaac, and Isaacs has a double S. So what did he say? He says that fee simple, so come back to the title, fee simple, stop using the word freehold when you're corresponding with anyone. I seize my property in an estate, and the in is very important. I seize my property in a state of fee simple. So Sir Isaac says that fee simple is the highest quantum. In other words, that is the strongest land tenure that you can have in the Westminster system. The only one above that is Her Majesty and Crown land. And the rights of the disponeur, which is the Crown, travel totally to you as the disponee, save for those reserved in the deed of grant. So that's how important that getting that copy of that deed of grant becomes as well. Okay? So it's the highest quantum. You hold that land in to the exclusion of all others. So the High Court have ruled, and this is Commonwealth versus New South Wales, Plenty versus Dillon, George versus Rocket, New South Wales versus Mrs. Abib. There's another one in the Northern Territory that's just escaping me at the moment, but there's a whole stack of them. And Mrs. Abib's was 2008, but I'll stand to be corrected on the date. Her son had done something wrong, went to jail, had actually served his sentence, was out of jail, and the cops started chasing him. He was driving his mother's car, doesn't determine whether he'd done anything wrong even. He got to his mother's place, flipped the roller door up in the garage, hit the button. The roller door had almost got to the floor when the cops got under it, and the two of them just forced it back up against the roller door closing and came in with the locks out. And at that point in time, Mrs. Abib, in her nightgown, walked out of the house into the garage and ordered them out of the garage. Well, they told her in no uncertain manner where to go, handcuffed her son, dragged him out of the garage and took him to the lockup. So when that eventually got to the High Court ruled, the moment Mrs. Abib said, "Leave my property," they had to leave. And that cost the New South Wales government $600,000 in punitive costs. So punitive costs, on top of that, she would have got court costs, costs for the anguish that it cost her, that caused her, etc., etc. The punitive damages are purely to try and ensure that, in this case it was the New South Wales Police, don't ever do that again. Right? Well, Plenty versus Dillon was the same, and his was 700,000. So New South Wales is not learning. So you hold your title, or you seize your title in an estate in fee simple to the exclusion of all others. You, I hate to use the word own, but the air above your property is your domain, so as the hereditaments and the tenements. So that's all of the nature that's growing on your property and anything that is built on your property. And in relation to the soil, so it's now talking about the land, right? You hold that in the same manner as you actually can hold it's not a good example, but a chattel, right? That's a chattel, it's my keys, I can seize them. But normally with a chattel, if you drop it, you can break it, so then you don't have the chattel. And what he is saying, you hold your land in the same way as you hold your chattel, except for its indestructibility. So in other words, you can't break your land is your land. Then he goes on to say also that you can develop your land to the extent of your imagination. So you hold it to the exclusion of, yes, I'm just likely to go away and leave that. No, I wouldn't, would I? So that's how important your land title is to you. You hold it to the exclusion of everyone. You control the airspace over it. You own all the natural facilities that are on it, if there's a dam or water. And also, you own your soil to the centre of the earth. Don't let any idiots tell you that you only owe 6 inches or 12 inches. Bullshit. You own it to the centre of the ground. So what, and that's why the Crown reserves the minerals, not for the Crown, the royalties from the Crown, Her Majesty says, goes into consolidated revenue for us to provide services. So if there's any water under your soil, who owns it? Yeah, we do. I asked Tom Gilmore many years ago in a cane growers meeting in Cairns. I said, Minister, and he was the Minister for Mines at the time, can you tell me when the state government takes ownership of water? Is it when it's in droplets in the air, falling through the air? Is it when it runs across the surfaces, the mets and bounds of properties? Or do you only take ownership of it when it actually reaches the beds and banks of a creek or a river? And of course he knew where I was going. He said, Senator Harris, you know, and I know, with legal liabilities, I cannot answer that. And I said, yes, I know you can't, because you don't own it at all, even when it gets into the beds and banks. Because Section 100 of the Australian Constitution says that we cannot be stopped from drawing water that passes our properties. That doesn't mean to say you haven't got to be considerate in your use. Okay, so that pretty well sums this one up. And of course I've saved the worst one for the last. It's a pity there's not some good news in this thing. Anyhow, we've had lots of laughs. Okay, Micah Hearn, what year? 87. Peter Beattie's Reprint Act, 92. Mrs. Wheelbarrow's Act, 2000, and we'll say 13 when it was accepted for everyone, right? The Headache, 1st of October 2019. So this one is Queensland Futures Fund, open bracket, Title Registry Act 2021. Okay, so 1st of July this year, this Act was created. So any guesses on how it was created?
Reprint.
Whoever said reprint is correct. The lady in black. Yes. I have absolute infinite information that this Act is a reprint Act. What they did, they took an old futures fund, gutted it, handed it over to the Bearcats. They put in it, obviously, what the government wanted. It was then sent to the government printer, printed, sent back to the governor, and the governor, as a result of Micah Hearn's original back in 87, making the governor, or taking his ability to reserve a bill, he or she stamped that. Now, you heard just recently where the, what's the name, Commissioner, Integrity Commissioner resigned. Do you know why she resigned? The Queensland government raided her office and confiscated her files and computers. Wonder why they would have done that? Wouldn't have anything to do with her investigating proprietary limited companies that the government had set up. Voila. This is the Act. There may be more. I'm not saying this is the only one. So, what did they do in the Queensland Futures Fund Title Registry Act 2021? Okay. The main purpose of the Act and how it is to be achieved. The main purpose of this Act is to support the state's contribution to the Queensland Future Debt Retirement Fund, established under the Queensland Futures Fund Act 2020. So they're saying that this Act, this Queensland Futures Fund, funny title, why would you put title registry into a Futures Fund Act? Anyhow, it's there. So that is what it's supposed to do. The declaration of the operator. Queensland Titles Registry Proprietary Limited, ACN 648-568-101, is declared to be the operator for this Act. So we have an Act of Parliament that actually creates a proprietary limited company to operate the Act. Next section, functions. The operator, so that's the proprietary limited company, the operator has the following functions: to perform titles registry functions delegated to the operator or other functions given to the operator under a title registry act. So they have just made a proprietary limited company the operator of the titles registry. I thought that's what we had public servants for and departments. Not anymore. So you're starting to get a little bit of a sense of why the integrity officer was a little pinged off. She was asking questions. Big questions. B, to decide. Well, what is there to be decided? Well, when you go to the back of the Act, you'll find it's all the charges. Matters for which fees payable. Computer programming. For each hour or part of an hour involving computer programming, excluding any part of an hour for which a fee under subparagraph I applies. Well, we'll have to find that one. The fee's $357.85 per hour or part thereof. So what it means is when somebody's buying a property, if somebody has got to sit in front of a computer and do a manual input, that would cost that person $357 to do that, even if it was 5 minutes or 10 minutes. What actually happens now is that when a title is being registered, the person who is purchasing the property has to enter into an agreement with a second party that has a digital signature. So the person purchasing the property has to sign to say they agreed that this person with the digital certificate, a digital signature, is going to lodge their ownership on one of those 3 computers somewhere out there. So it's not even your or my signature were we to be buying the property that actually lodges it. It is an unknown person that has a digital signature. So the proprietary limited company, that's Titles Registry Proprietary Limited, they get to decide what those fees are. And you can bet your bottom dollar that those fees will be tied to CPI. So every 6 months, say CPI goes up 2.5%, so do all the fees. So written into that forever is a ka-ching, ka-ching, ka-ching. And it's going to the proprietary limited company. And under B as well. So it says B, to decide, comma, collect and keep title registry amounts. And they're supposed to be there to pay down state debt. Okay, over the pages. Amounts the operator may collect and keep, titles registry fees, fees and charges under the Land Act, the Titles Act, and also any water allocations that are traded on the stock exchange. They have to be recorded by this entity as well. Section 2, title registry amounts. A, does not form part, they say consolidated funds, well we know that as consolidated revenue. So anybody who purchases a property since 1 October 2019, any fees they have paid for that registration of the title on one of the computers, right, which is all digitised, whoever owns those three authorised electronic lodgement operators, they don't have to do anything because everything is just automatically going onto their computers. So hence the digital certificate. The government's part of the fees goes straight to this proprietary limited company. And in the Act, and I'll mark it up later on when I get some, I've only had this one and the New South Wales Act. It was only when I got that last Friday that all of a sudden this whole thing just sort of lined up, because I couldn't understand why all the states were doing this. Well, it was New South Wales taking that act to COAG. So as well as that, in this act, the operator can transfer a public servant out of the titles office to the proprietary limited company. And that person only has 12 months if they wish to object and be transferred back. The other thing it also does is that it allows the minister to transfer funds into this proprietary limited company. So in 2021, in the budget, now remember, this act didn't come in until 1 July 21. In the 2021, so that's up to the 30th of June, the government had already allocated $5 billion to go into this proprietary limited company. And they had also made allocations to transfer 7.4 million Horizon shares into that proprietary limited company. Who owns the company? That's interesting. I did the public search and I got the name of the company and the ACN number, and then stupidly I shelled out another $19 for an extract of the directors withheld. Now, how you register a company on ASIC without putting the directors' names and their dates of birth, yeah, the lady's saying you can't. Well, you can't. Well, they have, and I suspect, I have heard of that the last three digits in that, 101, I think there is something associated with that allows them to do that. So they've tipped $5 billion into this account, plus 7.4 million Horizon shares. And somebody who's had more smarts than I have in Rockhampton yesterday went, and an Horizon share is $3.78, I think he said. So that's the value of that. So what did the Queensland government do then? They trotted off wherever, and based on the assets in this private company, went and borrowed 2-point-something billion in loans. So this is not a facility to actually pay down state debt. In actuality, it's a means of increasing it. And how could this be? Now that's a head scratcher. However, somebody smarter than me said, I can tell you, Len, because one of the groups who actually give governments their triple or quadruple A actual ratings had advised the Queensland government that they were looking at reducing their triple A rating to 2-point-something. Now, the moment that would have happened, it would have made it difficult in two ways. First of all, for Queensland to go offshore and borrow money, so there wouldn't be a lot of people who were too interested in loaning money to say 2.5. But also, if they did, they would also want a much higher interest rate. So this, in actuality, part of its purpose, not stated, is so that Queensland can try and hang on to its AAA rating. Well, they're nice and quiet. I normally refer to them as temporary Australians, but I can't that lot. Yeah, so the Minister has a defined time within this Act to transfer assets into this Act, and that, I believe, ends on the 30th of June this year. The Minister can also transfer people who work for the government to the proprietary limited company, and it gets to receive, and that's the reason why it gets to receive and keep those funds. So, ladies and gentlemen, there isn't any more bad news. The good news is I'm going home.